It's so interesting to me that the declaration that the tenant submits doesn't say under penalty of perjury. Did you notice that? It says under penalty of law.
Yeah.
And it doesn't say what law or what penalty. It doesn't say anything about it at all. Yeah. On the flip side, when a landlord has to submit an affidavit saying either that the tenant was acting, damaging the property or acting in a certain improper way, harming other people at the property, that is under a penalty of perjury. See the duality there?
Yes.
I mean, it really struck me. It's a minor point, it's a little thing, but it's pretty damn clear that there are no teeth to this declaration at all. The only thing that we're fighting about, and you fighting on behalf of your clients when you're in court, is really, can I get a judge to agree that there is no hardship? Not that, can I get a judge to penalize this tenant for lying, because they just did. Clearly, since they didn't have a hardship and they submitted this declaration, we just proved they didn't have a hardship. Hey guys, it's Vitaly. In this video, I joined my friend Matthew Lyman on a live stream on his YouTube channel where we discussed the new law that was just passed by the New York State Legislature, which extended the eviction moratorium in New York through January 15th, 2022. For those of you who don't know Matt, he's an eviction attorney in upstate New York. He's also a fellow landlord and the host of the Landlord Advocates channel on YouTube. Matt has been practicing for over 30 years, and he's very knowledgeable about landlord and tenant law in New York. We talked about many different aspects of the new law, as well as our personal stories and the different hardships that both Matt and I had to overcome to get to where we are today. Despite a challenging family life early on in his life and some long-standing health issues, Matt has worked extremely hard to achieve the personal and professional success that he enjoys today, and I was honored to join him on his live stream. I encourage you to check out his YouTube channel and to watch the full uncut version of this video, as well as his other videos for helpful information and tips on how you can navigate the eviction moratorium and the rental assistance program currently in effect in New York. If you guys enjoyed this video, please do me a favor and hit the like button. And if you haven't yet subscribed to my channel, be sure to subscribe and hit the notification bell so that you don't miss any of my future content on real estate investing and personal finance. All right, so without further ado, let's get into the video.
This is the Landlord Advocates, where we help landlords become better landlords. I'm your host, Matthew Lyman. Welcome. Well, I'm actually your co-host tonight. We have a very special guest who is joining us to talk to you about all of what's been going on over the last week with New York State. His name is Vitaly Volpov. Vitaly is an attorney, and he is also part owner of Serenity Real Estate in Albany, New York. We're going to discuss with you so many aspects of this new eviction moratorium. So without further ado, let me welcome Vitaly into the studio.
Matthew, thanks so much. Can you hear me?
I can hear you very well. Thank you.
Awesome. Thanks so much for having me here. Thanks for that introduction. I really appreciate it. And I'm glad to be here to discuss this important topic for landlords here today.
Well, I will tell you, landlords, Vitaly has Succeed REI on YouTube, and he's active on Facebook as I am, as most of you know that. And we have shared videos. We've talked about our videos. We have commented on each other's comments on social media. And I said to Vitaly, how about you and I doing a collaboration video? And without hesitation, he said, let's do it. And this opportunity came when we said, hey, let's talk about this new eviction moratorium. And Vitaly said, absolutely, let's do it. Now, what we want to let you know, Linus, is this is information that we are providing to you. Take it as you will. We advise that you probably should hire an attorney to go through this process now because it's very extensive. So we advise that you might want to hire an attorney for this, but we are going to provide you with a lot of information. The law is 71 pages long. It is very, very extensive. It is ridiculous. We are only going to focus on the ERAP program. We're going to focus on non-payment evictions, holdover evictions, and defaults. So please have your comments and your questions related to just that. Anything else we have not focused on. We have a lot of answers for you, but we don't have all the answers for you. That's why it is best to consult with an attorney. But we are here tonight to talk about that. Now, let's move right into the ERAP program. As many of you know, that is the Emergency Rental Assistance Program, where $2.6 billion was afforded to New York State to share that among landlords who have not been paid in a very long time. It's been very dismal, and I'm being polite when I say that this money has not gone out. And we believe that there's a reason for that. I was at a meeting last night with a representative of a tenant advocacy organization, and we actually got along very well. And I asked her, I said, if a tenant applies for this ERAP program and they omit information, they have about 10 days to respond and provide the additional documentation. I said, what happens if they choose not to do this and they get thrown off of it? Their application gets dismissed. Are they able to apply again? Her answer was, yes, they can. And I turned to the landlord group. I sat in the front row and I turned to them, as we have said on social media, and I believe Vitaly has done the same thing, is that this is just another built-in eviction moratorium. This could go on for months and months and months with this ERAP. Now, we have said in previous videos, here in New York, you must accept ERAP. If not, that is against the law. It is against the fair housing law called, I'm sorry, not fair housing, but discrimination, human rights law. They call it lawful source of income. Now, I will tell you that I do not believe that that is a lawful source of income. Income is what you get when you provide something to someone else, not something that you just get from the government put in your pocket. But either way, that's what they call that. So you have to accept this program. So landlords, you really should apply, even though you may not want to, because it will only hinder your eviction with the ERAP program. So you really should apply. We know landlords that have got money. Some of our clients have got $10,000 to $15,000 of what's owed. But we have said it's smoke and mirrors. I know Vitaly has done a couple of videos on the ERAP. Vitaly, add something here. What do you think? Add anything that you may want to say about the ERAP.
Sure. Yeah. I mean, generally speaking, guys, I think if you have a choice, if your tenant is cooperating with you and you're able to apply, there's really no reason to hold out. Matt is going to get into, we're going to talk maybe a little bit about what happens if you do apply, you receive the funding, and what restrictions the government will place on you if you do receive the funding after the application. But regardless of that, that's not a reason for you to hold out, because the way these laws have been going and the extensions that we've seen after extension, and now with this new response to the United States Supreme Court decision from August 12th, they're clearly intent to continue trying to extend this. And eventually, if there are arrears from this pandemic time period, they're probably going to be forgiven. And so if you don't apply right now, if you miss this opportunity, there's good opportunity to receive up to 15 months of back rent right now. Now, as Matt alluded to, I am a landlord myself. I'm a real estate investor primarily, an attorney secondarily at this point. My roles kind of flip-flopped over the course of time. I was never an eviction attorney, but I'm certainly very keenly interested in this specific topic in New York State because I am a landlord. I am a real estate investor, just like you guys are. I have a law-trained background, so I can understand these laws. I can read them. I can find out when these things are happening. One of the first people to find out what's happening and then interpret it and know what to do and how to act within my business. But at the same time, I'm still in the trenches just like you guys are. And I would definitely suggest that if you have the opportunity, if you haven't yet applied for rental assistance, that you definitely do so.
Absolutely. Apply, you may not want to, but you have to. Plug your nose and apply. You will get money. The problem that we find with that is that the idea is that you're going to get all of the money. You may not. You may get just a portion. And whenever you don't get in that covered period, for lack of a time frame, we're going to say January through December. Let's just make up a time frame. Your tenant owes you $12,000, $1,000 a month. The government determines that you will only get $500 a month. So therefore, you're getting half of what is owed. The other half that is owed, bye-bye. You can never ask for it. You can never sue them for it. You cannot evict them for that. If you choose not to apply for ERAP and your tenant is approved, that money would be held up for 6 months in order for them to say, well, you didn't apply. And during that time frame, you cannot evict them for non-payment of rent. You're not going to do a holdover eviction because the money has been afforded to you that you were asking for. And like Montelli mentioned, there are restrictions on that. You cannot evict them. You cannot raise the rent. On a holdover, meaning the expired lease, you can't evict them for that. So what was stuck in that the government says you must accept this money no matter how much it is. The government could be a real SOB if they wanted to and pay you $100 of what is owed, and you have to forgive the rest. It'd be great if we could do that with a tax. We were watching the other day with the assembly vote on this bill, and Assemblyman Jeff Dinowitz from the Bronx, for the show, I will maintain composure, but his idea was to the other assemblymen who were against this, and women who were against this ERAP, was that, well, the landlord will be able to get a judgment with that money, and they will be able to pay their bills with that money. I mean, that is the most ludicrous, foolish statement. And if he actually believed what he was saying, that is scary. I know in my over 30 years in this industry, we have over $5 million in uncollected rents that our clients will never see. And one of the lies that we tell our clients in our office, and we are right there with them, take toilet paper and that judgment and tell us what has more value. After one trip to the bathroom, you will know the answer. So the judgments are meaningless for most of us. And the tenants know that, and the government knows that. But they believe that we landlords are a little stupid to believe that, oh my God, I'm going to get all of my money, when that's not the case. So in the ERAP program, you have to apply. We don't like it. If you get your money, that's great. If your issue with your tenant is just the money, we understand. Apply. You may not get what is after that. Now, with the ERAP program, if your tenant gets the money and the payment is through the end of, let's say, September 2021, and the tenant fails to make payment on that rent for October or November, you can initiate a non-payment eviction right after. So the money that comes to you is September 30, 31, I can't remember, September 30th, and the money is paid for you. Come October 6th, go right ahead and initiate a new eviction on them. That's the ERAP. If any of you have any questions regarding ERAP, go ahead and post them now. We will try to keep up with whatever questions you may have. Some comments, we'll throw them up on the screen. But Montelli and I are going to share what we know. Again, this is 71 pages long, and they reference Section 6, Part AA of Subsection BB of Section 56 of the laws of 2020. It is obnoxious. It is obnoxious. But anything else about telling on the ERAP program?
Yeah, so maybe you'll get into this in a minute, but there are a few changes that have been made. They're mostly, as I look at them, mostly cosmetic changes. One of the things that they closed a loophole. Some people are perceiving this as a loophole. If you guys are familiar, there's the state program, New York State program, currently administered by OTDA, which is a New York agency. And then there were, I think, a handful of municipalities, I think maybe like 7. City of Rochester, Monroe County, City of Yonkers, Onondaga County, and the towns of Hempstead, Islip, and Oyster Bay. Those were the 7 municipalities that opted out. They all received their own chunk of money from the federal government, and they said, we're going to administer that program on our own, and so we're not going to participate in the state program. So those individuals who were living in those municipalities were required to turn to those municipalities first and foremost in order to get any rental assistance, whether landlords or tenants. And some of these programs, as far as I know, and I've heard from quite a few people, this is months ago now, have already processed them, given out the money. It's all been done in a much more efficient manner than the New York State program has been. And what was kind of circulated out there and argued potentially is that the state ERAP requirements and restrictions that the New York State law imposed did not apply to landlords and tenants who applied through their own municipalities under those municipalities' programs. So that was the argument. So that's kind of a loophole. So maybe the requirements on landlords after accepting rental assistance in those municipalities are not as restrictive the argument was, as they are under the state guidelines. Well, so this new amendment, what they just passed, gets rid of that. So that's all gone. They're basically saying, regardless of what program you applied under, you're going to be restricted from raising rent on this tenant who received rental assistance for a year after the receipt of the first payment. So the rent has to stay the same. And you also can't evict them for any reason other than non-payment of rent. And then a couple of exceptions that maybe we'll talk about with Matt with regard to tenant intentionally causing significant damage to the property or persistently and unreasonably engaging in various behavior that is a problem. So those are really the only ways that a landlord can evict a tenant after receiving rental assistance funds. And previously there was an argument, at least, that maybe if you're in one of those municipalities, that didn't apply to you as a landlord. That wasn't a restriction on you. They got rid of that.
And with the ERAP program, they are trying to do a little bit better, but even the tenant advocates, they called up and one of the representatives that is a state worker. They have an agency that they paid millions of dollars to run this program, and very abysmal, very terrible. So the state supplemented that workforce with state employees. And we asked on our channel, we actually demanded that not 1 rent cent of taxpayer money going to pay those state workers. It should come out in the contract of the company that was paid to do this. A tenant advocate the other day was on the phone with the ERAP representative, and what they heard on the other side was the person had fallen asleep. They were snoring on the phone. The people at ERAP, they are getting a little cheat sheet. You know, when you call in and complain about something, well, I'm sorry to hear about your complaint. And you yell, I'm sorry to hear about your complaint. It's a Rolodex of bull that they're telling you. So some of these people at ERAP don't even know what the hell they're talking about. And when they sent the people out, the agencies to administer these programs in these municipalities, they gave them no direction. They gave them nothing. It was intentional. They may claim that it wasn't, but it was. As of July 27th, the numbers have increased, but on July 27th, there was 160,000 applications pending in New York State. Out of the 160,000 applications, only 55 were approved. Only 55. So with the ERAP, there is some comments here that I see, and I don't want to lose you in the comments or questions. So we're going to jump into the ERAP questions, and then we're going to go into the non-payment of what you can do when you want to bring a case to court for a non-payment eviction. If ERAP pays in December 21 with the 3 future months, I can apply for an eviction in January if the tenant has not paid rent by 1/8. If the tenant is not paying the rent, you can. If the rent is being paid, no, you cannot. And if they're continuing to pay the rent a year after, you can evict for a holdover, but not before then.
I have one here, Matt, that I can take.
Oh, sure.
What if the landlord does all the paperwork for the ERAP program and the tenant does not submit anything? And when I read the summaries, and Matt, correct me if I'm wrong, when I read the summaries of this new law from various sources, I think New York State Bar Association did a summary, some other folks, journalists did summaries. I thought they said that they were giving landlords an opportunity to apply even when a tenant does not comply. Yep. But I did not see that in the 71 pages that I read. Did you see it? Okay.
It's not, Vitali. There is another bill out there that they have, I think 100 million or 200 million. I will be honest with all of you here, and I think Vitali, I speak for him. We have focused so much on this 71-page law and digesting it, and we are educated. Him and I are both educated. My team has over 100 years of experience together, and even then we have to sit down and analyze this. So we did not delve into that. I think Vitali and I will probably do something on our YouTube channels or even here later on to talk about the money that you can apply for if your tenant does not apply on their own. Because when a tenant doesn't apply, they're just trying. And what will happen is they will not apply, and then the day that you have them in court to evict them for not paying the rent, they're going to apply. And the court is mandated to give them that information that they can apply. Now, with the program with ERAP, under this new law, the OCA, Office of Court Administration, now has to have in front of the court clerk the ability to look on the computer to see whether or not the tenant applied for this money. Now, apply does not say they got it or they sent in their name and that was all that it did on the application. It will not tell us that, but it will say that they applied. It won't say when they get it. Now, with the ERAP, and I think a lot of our people here and Vitaly would see, is that with the ERAP program, not one person on our social media that I have seen has received any letter stating your tenant has been denied. A lot of pending, no denial, a lot of pending. And I have said just recently, when it comes to that, they may have been denied. But now the ERAP representatives are looking all around to find out where that is that the person was denied. Because once they're denied, you can move to throw them out for not paying the rent. So by putting the pending aside and putting they really should be putting aside the ones that were denied, because that's totally immoral, unethical, and illegal in my eyes. But to say pending is another word for we're going to deny you, but we're going to pend it out for who knows how long. It's just unjust, very unjust. Evan is an attorney in the Bronx, and he is an early follower of the landlord advocates, and he's been a friend of ours. And had a judge tell me that the new law has a rebuttal presumption that the hardship exists, so I have to prove a negative. Most of my cases are holdover cases where the person is not a tenant. ERAP can't help those New York landlords. We're going to talk about this hardship rebuttal shortly, Evan, and we're going to talk about that in the non-payment aspect of it. Now, the rebuttal of the declaration, you're right, I don't believe, and Vitaly, jump in here, I don't believe that the declaration of hardship will apply to the intentional and the substantial damages to the property. Now, they may fill out the declaration because we have to give it to them, but I know that they will have the immunity of not being evicted if they are causing all of this damage.
Yeah, my understanding is that that's right, that they can submit a hardship declaration even if they are causing damages and acting in a harmful way to other residents in the building. It becomes, as Evan says, you kind of have to prove the burden of proof is stacked against landlords because they have to disprove certain things and they have to prove certain things that they may or may not have ability to prove, because in order to prove something, you need to have access to information. And when the tenants are holding all of the information and all they're doing is submitting a hardship declaration, now we're going to have a very hard time overcoming that. And this is one comment I want to make about this in the more broader sense with what happened in the Supreme Court on August 12th, when the Supreme Court struck down CEFPA's, I'm abbreviating it that way, but it's the one that was...
It's COVID Emergency Eviction and Foreclosure Prevention Act of 2020.
There you go. Say that 5 times fast.
No way.
So that was the law that basically said a tenant can submit a hardship declaration, and that declaration will serve as a full stop, hard stop on any eviction, any executions of warrants, anything basically. And it had to continue without challenge up until whenever the latest extension of the deadline was due. And so landlords challenged that. Supreme Court said, you're right, landlords, that was a violation of your due process rights. You can't have someone simply say, I'm just going to declare that I have a hardship and no one can challenge it, and therefore, I'm going to infringe on landlords' rights. So Supreme Court struck that down for that reason. So now the legislature went back, and what did they do? And I was looking for this. I wanted to see exactly how they will address this issue, because I knew in the summaries before I read the law itself, they said, okay, well, landlords will get a hearing now. Awesome. I thought, well, let's see what the details are, right? You go look at the details. There are no details. The details are essentially that, yes, you get a hearing and you have to ask for it, right? So a tenant submits a declaration of hardship. A landlord receives it, and it's up to the landlord to affirmatively, or through an attorney, affirmatively request a hearing challenging that declaration. And the landlord must have a reasonable belief, a good faith belief, that the hardship declaration is invalid. And then they show up to court and they have to prove that it's invalid. And good luck being able to prove that unless you have some kind of an admission from a tenant, right? If a tenant sent a text message to their landlord saying, haha, I have the money, but I'm not paying you. Maybe that will be some good proof. But unless you have their records, have their employment records, have their financial records, which of course you wouldn't. In a summary eviction proceeding, you don't even have the right to collect discovery as you would in a normal lawsuit in the first place, right?
I'm going to talk about that momentarily.
All right. I'm jumping the gun, Matt.
Oh, no, that's right. Vitaly, we are co-hosts. I'm not the host, we're co-hosts. We're equal here, okay? But we have some great information that will, Vitaly will say, really, wow. We have had, since the passing of this law, we have had about 30 cases in court. Between yesterday and today and the second or the third, I can't remember, we had more cases in court there. And we had some great results. If tenant filed for ERAP up to June 20 and 21, but has not paid anything for July, August, or September, I have not received any ERAP funds, can I evict? No. And we're going to tell you why. You said filed for, you did not say got paid for. If you got paid for June up to June 2021, and that's all they're going to pay you, then yes, you can. So if you want to send us back a clarification on that, but as your sentence reads now, no, you cannot evict. No, you cannot. This one here, we will be discussing this. Right now, we're going to talk about non-payment of rent and how we proceed with that under this law. And then we're going to talk about holdovers, and then we're going to talk about the defaults with the sheriff. The news is bad. It's bad. But like we said in our thumbnail, we're going to show you ways that you get around this. And one of the ways is that when you file for non-payment of rent now, we all know that we had to include the notice of legal service providers. We had to include the declaration of hardship. And then there was a state form. We call it a state seal, the unified court system. We had to include that. We have not seen anything yet from the Chief Administrative Law Judge, Lawrence Marks, whether or not we have to add that. But we are adding it. And there's certain terminology that you have to add. The old one has information on it that you can't challenge. The new one does. Now, we have a great studio here, but we were not able to put an overlay in of what needs to be added. But I am no problem reading that to you or putting it up to the screen. And then when you are watching this in rerun, you can freeze it and realize that now that is what has to be inserted. So when you take it for non-payment of rent, you do the rent reminder, the 14-day notice. With all of that, you have to include the declaration of hardship, the notice of legal service providers, and I still am doing the state seal form that tells them when they can go and get help, that your landlord can't do this and can't do that. You still provide that. The court, one of our local courts said, no, you don't have to worry about that in the middle of August and earlier. In those cases that we were told you don't have to worry about, we actually told the clerks who we get along well with that no, that's not how it works. The law is through August 31st at midnight, so therefore any documents that you serve upon your tenants must be accompanied by the requirements under the law through August 31st, 2021. And we were right. We had cases in court yesterday and today, and two different judges, and the judge that heard our cases today opened up the file, and my colleague was there representing quite a few of our landlords. He opened it up, the judge did, and he realized that all of the evictions had the accompanying documents that were necessary. So there was no need to adjourn them out just for that purpose only. So continue to keep giving those notices out. You do not have to give out the CDC form anymore. That was the colored form. It had to be on anything but white paper. That you don't have to do. So do that with your 5-day, do that with your 14-day. You can't serve it yourself. Again, you would hire somebody. Vitaly is stepping back from that, but you would hire colleagues that he has. You would hire my firm or anyone like us that knows what we are doing. Here's where it gets tricky. And this is almost like a diagram that you would put up on a big wall, because if they don't do this, you can do that. If they do this, you have to do that. So pay attention to what I'm telling you, everyone. Pay attention. If you want to take them to court for non-payment of rent and they hand you the declaration of hardship before what we call pre-petition, meaning that you have not applied, you did not pay the filing fee, you did not get a docket number. If you have not done that and they gave you the declaration of hardship, you have to provide to the court an affidavit, as we've always done during this CFA, that you do not believe, or that your tenant did not return the declaration of of hardship to you, and these are the dates that they were providing it, and as of this date that you signed and notarize it, that you did not get that back. That has to still go with the documents that you give to the court to get your court date. Indecima, landlord tenant summary proceeding, housing court, whatever you call it. When you give them that paperwork, there is now additional paperwork that must accompany that. When you serve your tenants, you must give them a document that looks just like this. This document right here has to be on every petition paper that you give. And they actually say it doesn't have to be inside, it must be on top. So when you give the court paperwork, the petition and notice of petition, you must have that notice on top. And if not, you might get a judge that says, case dismissed. You don't want your case dismissed on procedural errors. We had that happen in a local court. It was not one of our cases. It came to us afterward. And the judge said, you did everything right, but you didn't do this. And they dismissed the case without prejudice. Now, one of the things that happens with pre-petition, if your tenant supplies you with a declaration of hardship, this is where we got into vitality. We were in court yesterday, and we had a number of tenants show up. And when they claimed that hardship and they gave it over to the court, which the court will be there, the tenant advocates will be there, and they'll be waiving all of them. They're going to be giving them out like they give out candy on Halloween to children. So don't say, oh, they're not going to sign it. Get that idea right out of your head. They are going to do it because it's in their best interest to do it. But here's where we got into vitality, and it was great. Even the advocates and the court were like, wow. We had judicial, subpoena, duces, tecum ready to go. So when the tenant did either side A or side B of the declaration, side A is the financial side, which is a lot of crap. And side B is, I'm over the age of 65, I'm immunocompromised, I'm da. When they submitted that, while they were giving their diatribe in front of the judge, we were filling out the subpoena, and bam! They were served that judicial subpoena, duces, tecum. So on the adjourned court date, they need to provide, if it's for financial, W-2s, tax records, pay stubs, anything that they are claiming that they have a financial hardship, they must provide. If it is one where they're claiming immunocompromised, we have one that said yesterday in court that goes against HEPA. No, it does not. You have made a claim in court as a defense to not getting evicted. And I love it, Vitaly. Thank you for shaking that head. I like that. You made a claim. You cannot make that claim without substantiating that claim. And when you take those tenants to court with that subpoena and they do not provide the information, the court will presume that they are not providing it because it is damning to them. And therefore, the court really has no choice but to rule in favor of the landlord. So you would want to, now, landlords, you don't know about judicial subpoena, duces, tecum. That's about records. You don't know about serving that. You don't know about that. No disrespect to those of you that do, but we have to presume that you don't. And it is in your damn best interest to hire professionals. It may cost you, and it will. There's a lot more work that's involved. Fees have to go up. But you have to look at it this way. If you do not challenge this declaration of hardship in court, that notice says right here that the landlord cannot do anything until after January 15th, 2022. So they will adjourn that case out until, and you may not be in court, your tenant will be there until Happy St. Patty's Day. And that's if you're in the area that Vitaly and I are in upstate New York. If you're in New York City, it's going to be Merry Christmas 2022. If you are looking to bring forth, the 14 days is fine. If you don't want to get a court date, your tenant may say, oops, I'm going to pay the rent or I don't want to get evicted. Before you file for the eviction for non-payment of rent, you have to ask yourself, or we will ask it for you, do you believe in good faith that your tenant is lying, and that you can prove that they're lying, and that you are willing to pay the funds necessary, have the notices served upon the tenant, and take the risk of going to court to be able to prove your case? If you do not believe that this is the case, it is not worth taking the non-payment all the way, because they will adjourn it out, and that'll be in January, February, your case will be heard. But you have to look at the fact, this is September 9th. You're looking at 5 more months of saying, well, I'm not going to fight it. Look at the amount of rent that you can be losing. You can be losing $5,000, $6,000, $7,000, $8,000 in rent, where you don't know what's going to go on. And that ties into the ERAP application too. You are allowed to file all the predicate notices. You can serve them all. Predicate meaning rent reminder 14, 30, 60, 90. You can do all of that. We suggest that you do. And even get a court date, even though your tenancies have applied. Because it may be 4 or 5 months later that you will find out, sorry, we're not giving you anything, and now you initiate the eviction. What will happen is if you apply under ERAP, the court will just adjourn it out until they find out that your tenant has been denied. If they have been denied, then, bam, that next day in court, Your Honor, I want a judgment for what they owe me and an immediate warrant of eviction. Now, when you do this, when we are providing this non-payment summary proceeding landlord-tenant documents to your tenant, we will have to include in there the affidavit that you get the court sworn that you believe in good faith that your tenant is lying. Now, you don't necessarily have to sign it if you hire an attorney to do that for you, because you in the affidavit that is being drawn up, the court did not give that to us, so we have to do that ourselves. Just like with a lot of other stuff, or the default notice and the default hearing, we have to provide that. We have to write it up ourselves. But you have to provide that affidavit, and if you're not represented, or if you are represented, we can do that for you, because you are saying that you believe that this is the case. We are not affirming it. My team is not affirming it. Vitali is not affirming it. It is just that we are signing it because you told us what you believe. That has to go in the court papers as well. That is the way that you can proceed with a non-payment. So don't give up hope. The problem is that now they're going to use this ERAP application as the eviction moratorium, because now you can challenge this hardship. Be prepared. There is clauses in that I've hated since day one, and Vitali, I know you're going to agree on this one, that I fear catching COVID, and I have no money for out-of-pocket expenses to move. In the video that we did on that, we said a 12-pack of beer, a 24-cut pizza, and you go to a major company, moving company that charges $19.99 to move your stuff, $50 you can move your crap. And one of the things that we said recently with the Kathy Holcomb video that we did about rules for thee but not for me, in that we had said that these people are in the midways, the fairways, the hallways, everywhere that you can possibly be, mingling with other people. And when you ask them what COVID-19 is, like, what's that? But the moment you mention COVID-19 and an eviction, oh no, I'm afraid I'm suffering. No. And then we'll go to an advocate, and the advocate will walk them through the process to delay that eviction. I know it's cumbersome. I know it's overbearing. I know it's hard on us, but we can't give up hope. We can't give up hope. And that's why you come to people like Vitali and myself and my team to help you through the process. So that is how we can do non-payment. What I will do here is I have been negligent in looking at comments, but I want to see if there's anybody that has been in court since. I doubt it, Vitali, because a lot of them we've held back. We actually have over 70 cases that we held back from applying for a court date because we didn't know what was going to be needed. And the rules, and in the holdover, which we'll discuss momentarily, the holdover ones are worse. Because if you've applied and you got the court date, you may have to apply all over again. But if you held back, we've done, and we've had some landlords who have been lovingly irate with us, and they know I love them. They've been with me for over 3 decades, and I told them, I said, I am not going to move forward with any of these cases, nor any of my team members, because you want us to. I don't care. We're going to interpret these laws. We're going to understand these laws as fully as we need to make sure that we proceed. And landlords, if this costs you a week or two, I don't care. I don't care. I do, but I don't, because I'm not going to jump in and get you in court date. We're not going to be in court. And we're not going to see your case dismissed and have you turn to us and cry, literally cry, Matt, what am I going to do? What you're going to do is you're going to listen to us so that we do the best thing for you. Vitaly, I'm sorry, next time we do a live show, I'm going to make it so you can pop up comments.
That's okay. Yeah, that's all right. Matt, I just want to...
Hey, Vitaly.
Okay, I just want to point one thing out for people, and it just piggybacks off what you've been saying. I think this is prime example. The subpoena duces tecum that you mentioned, doing that in court, that is something that if you are trying self-help as a landlord and you're trying to do an eviction right now by yourself, I mean, you are really just not serving your own interests. And I think something like that, only an attorney who's well-versed, who does evictions, who's on top of these sorts of things, is ready and prepared with something like subpoena like that. A normal person, an average person who's not an attorney, even an attorney who doesn't necessarily practice in eviction court every day, I certainly don't. You know, you might miss this opportunity because it's so hard to, like I started saying earlier, hard to obtain any information from the tenants. But in Matt's case, as what he was describing, in that situation, the tenant's already in court, and it's the perfect opportunity to serve them with a subpoena so that now they don't have any excuse. They just got served in front of the judge. They have to show up next court date with all the documents supporting their declaration. The other point I just want to make real quick about the declaration, and I noticed this, I don't know if anyone else caught this, but it's so interesting to me that the declaration that the tenant submits doesn't say under penalty of perjury. Did you notice that? It says under penalty of law.
Yeah.
And it doesn't say what law or what penalty. It doesn't say anything about it at all. Yeah. On the flip side, when a landlord has to submit an affidavit saying either that the tenant was acting, damaging the property or acting in a certain improper way, harming other people at the property, that is under a penalty of perjury. See the duality there?
Yes.
I mean, it really struck me. It's a minor point, it's a little thing, but it's pretty damn clear that there are no teeth to this declaration at all. The only thing that we're fighting about, and you fighting on behalf of your clients when you're in court, is really, can I get a judge to agree that there is no hardship? Not that, can I get a judge to penalize this tenant for lying, because they just did. Clearly, since they didn't have a hardship when they submitted this declaration, we just proved they didn't have a hardship. No penalty. There's no penalty at all. And they are giving them out like candy at the door with various advocates. They walk in, they get their signature. Previously, before the Supreme Court decision, it was even easier. Now, guys like Matt are there to at least fight for your rights if you're a landlord in court.
Yeah. Now, when they do, now let's say your tenant doesn't give you the declaration of hardship at all during the entire process and in court. What will happen then is, as a non-payment, I'm doing the declaration, you can still have the subpoena served on the tenants, but at another date. When they adjourn it out, then the process server would have to go out and serve the subpoena on the tenant. It will be done in the courtroom. It will have to be done after. Now, you might say, well, why can't we give them the subpoena no matter what they've done? You can't do that. You can't ask them for records and documents to fight against them when they have not made any allegations to say that they have suffered. So the judicial subpoena cannot be issued until after the tenant has signed the declaration. If the tenant signs the declaration and you don't tell the court any of that, you really need to be honest with yourself and honest with the court that, yes, my tenant signed the declaration. Because if you lie about it and they prove that you've done that, Ron Thomas said, you're going to be in hot water. No district attorney in any of the 62 counties in New York State is going to take any of these cases that my tenant lied on that declaration. I want to prosecute. It's not going to happen because there's so many aspects of that declaration. I'm afraid of catching COVID. My out-of-pocket expenses have increased because of work. Well, I was at the gas station today, and it was $3.19 a gallon. That's a hell of a lot more than it was last year. Can I claim it? Sure we can. This declaration, any one of us can sign it. Vitaly and I can sign it.
The problem with that declaration is that, like you said, there's A and B, and then there are subparts under A, all the different financial potential hardships, right? And we don't know which one they're picking. They're just saying it's one of them. It says one or more. All you have to do is attest to having one or more of these criteria. And how do you challenge something that you don't know exactly what they're claiming? All you know is that they have either reduced costs, they have a loss of income, they have, this hardship, they have that hardship. It could be any number of things, and a lot of them are very subjective.
Most judicial subpoena duces tecum, as most of them are usually a half a sheet of paper. That's it. Ours at my office, my team's office, I should say, is 3 pages long. We have that thing, and we're crossing out what doesn't apply, and we're initialing, we are firing them off. But if they do it after court, then we have it more formalized. It's typed out, it's all of that. But we can't have it typed out when we're sitting in court. So we handwrite it all, and we hand it over to the tenant. So, hey, you got to provide. If you're willing to try that. Now, Lizzie is an ardent follower of ours, too. Her question is basically, my tenant is working under the books. They're applying for ERAP. I know that it's fraud. If I report them, I'm afraid to get any money. I want to tell you to do the right thing and report them, but you know that if you do, then not the landlord, but the tenant will be in hot water if they're proven, and the person that's hiring them will be in hot water as well if they apply for ERAP when they're working under the table. But will you get any of the money when that happens? I doubt it. But there's another program that you might be able to apply for later on that we'll do a video on, but this is more important for us right now. So you may not get the money now, but you might get it later. And there's a lot of tenants that are doing this. They're working under the table. They're not going to claim anything. And that's why some of them don't want to fill out the application. So if your tenant doesn't want to fill it out when you force it upon them, then the other program that is out there, which we have to study, you will be able to apply for that because your tenant is being uncooperative, and you may be able to get your money that way. But one of the things I tell everybody who gets judgments over my 30 years and thousands of evictions, do not count on ever seeing that money. More so now than ever. I know it's terrible. You may get a judgment. We had a judgment end of August against a tenant for $32,000 in court. She admitted that. She asked if she could have another month to stay. I said, no. We'll give you another week, but you owe $32,000 in rent, and you want another. Well, no. But we have to be careful with that because they go in front of a judge, and they can scream and cry and holler. And now, because of this new law, that warrant of eviction may be vacated, or we have to go back to court and have a settlement or a status conference. We're going to talk about that shortly. We're going to get into the holdovers momentarily, but Listen says, what health records should we ask for? You just ask for all. If they want to scream HIPAA and all of this other stuff, you do not have to say, well, I want to know. And then come to court and they say, well, I sometimes sneeze. Show us the medical reports that claim that because of that, you can't be evicted. If you have AIDS, if you have stage 4 cancer or whatever, absolutely. Submit the paperwork. We understand. Not that we totally agree with it because people may use that and they've been using it for months not paying rent. But health records, you don't have to be specific with what you're asking for. The subpoena just says, if you're going to come to court and claim that you have an immunocompromised disease or a situation that does not allow you to be evicted, be prepared to bring in the health records that corroborate your claim. And if you don't, you're out of here. So you don't have to be specific on what health records that you're asking for. Received a judgment in February of $23,000 in possession of 4 years, no rent. Yeah. We lead the chorus, the choir. We don't, we're not in the choir with you. We're leading it with you. And we've seen that repeatedly. New cars, jewelry, vacations to Disney World. Billions of dollars is owed in rent to landlords across America. And these tenants are having a damn good time. I have said this on social media. I don't know I've never said it on YouTube. I'm not sure. I know I've never said it on a live show, but I'm going to do it now. And no one yet has challenged me, and I dare anyone to do so. I am saying that COVID-19 has been the best friend that tenants have ever had. And it has. Prove me wrong. I don't know if anybody here wants to because they can't. Violation, subrenting, collecting. Oh, yeah, we've had that. We're going to talk about that in the holdover section, Rick. do you want to have anything more, Vitaly, about the non-payment or the subpoenas? Go ahead.
So one question that keeps popping up from a lot of different folks is, I have a property, a tenant hasn't paid me rent, and I want to either have a relative, close relative, move into that property and use that as a basis of for an eviction and get rid of a tenant, or myself, I want to move back into my property and I want to be in that apartment. Do you have a handle on that as a potential exception?
I do. When you want to evict a tenant, it has to be a 4-unit or less, and an immediate family or yourself has to move into that apartment that you're telling the person that you want to get them out. Now, the question is, what's an immediate family member? In my eyes, it would be mother, father, brother, sister, grandparents. I don't know if it will extend to aunts and uncles and cousins 10 times removed. So the farther out that family cluster gets, the weaker your argument will be. And this is legal. If you want to do that, move your 18-year-old kid in there. Get him out of the house for a couple of months. That you can legally do. I'm moving my son in. He's 18. He needs an apartment. He may not need it. You might have, my house is a huge house. I got plenty of bedrooms. But you just want to be able to get that tenant out. You move your son in for a couple of months. Son, come on back home. I love you. Then you re-rent that apartment out to someone else. You're not breaking the law when you're doing that. The law does not say the duration of time that the person has to live there, but under HUD regulations and FEMA and all of, not FEMA, but under Fannie Mae, Freddie Mac, my team has addressed that, and we have decided that 2 months of an immediate family member living in the home will satisfy that need to get that tenant out of the apartment. Go for it. Make it happen. Make it happen. And then we're going to get into the hold. And the holdovers, I will tell you, are cumbersome. There's different levels of that. Anyway, I'm not familiar. Evan's from New York City, and Vitaly and I are from upstate.
Yep.
And the rules in New York City are a monster, a Tyrannosaurus Rex, Godzilla, King Kong, all wrapped in one. And the thing that we are saying up here in upstate and outside of New York City, the rules in New York City are running up on us like the Roadrunner, and they have no idea because the problems in New York City are not the same problems that we have upstate. Right. But now they are, because the New York representatives of the state legislature believe that they are, and now they are becoming that way. Yep. So, Emma, I'm not familiar with that, but you know your stuff. If you're in the Bronx and you need an attorney, Evan is the person you need to talk to. Evan's the one to talk to. We'll move in and move forward with a holdover. Yeah. You don't want to go through the ERAP. Not wanting to, you don't have an option, Jack. You don't have an option to say, I don't want to go through ERAP. And Jack may have joined in late because the crowd is getting bigger on our show. You cannot say no to ERAP. But you can say, I'm moving my family member in. And that might say to the ERAP representatives and the local people, there's no sense doing this because you'll boot that guy out. What I would do, looking at how long the ERAP program may be, I would think, and how much they may owe you. Your tenant may owe you $10,000. One of our clients got $15,000 about a week ago. Get the money and then start the eviction on them. If you want to do that. Yet you have to take it personally to yourself, Jack, and weigh the consequences or the decision, not consequences, but your decision. Do I collect the money after ERAP and then throw their butt out so that my parents can move in? Or do I just get them out now and get my parents in there?
And just so people understand, what Matt is talking about is not collecting money for some future months and then immediately turning around and evicting a tenant. What we're talking about is back rent collected, and you probably won't even get all your back rent. There's so many cases where a tenant stopped paying in April or 2020, or possibly even before that, and they've been not paying for 2 years, let's say. ERAP is only going to pay you for 12 months of back rent and possibly 3 months forward from the date you applied. So I have some applications pending right now that I submitted for some of our tenants in July, and now we're in September, right? So that I asked for 3 months. They asked for 3 months going forward, but we still haven't gotten paid. So if we get paid by October, it would technically be 12 months of back rent plus 3 months of forward rent from the time we applied, but it's really 15 months of back rent because by the time we get the money, we're already in October and they've owed us this money this whole time. So the point Matt is making is just that if you have that option of potentially moving in a family member after the fact, and the lease is month to month or has expires, no term lease that you would be violating with that tenant. If it's not legally prohibited and you have the good reason to do it, such as a family member moving in, then that's totally up to you, and you can make that decision on your own.
Yes. On the ERAP application, we have not done it because we wanted it, but as I understand, you fill out the first page and then it moves into the second page. I couldn't get it printed out for me with, from the tenant advocate, so I do look for it, I'll be honest with you. But I'm told that there's a little box that you have to check to ask for the 3 months going forward. Go ahead, Vitaly.
So guys, I have a full, almost an hour-long video on my YouTube channel where I walk through every single step of the process of applying for ERAP online. You guys can check that out. The channel is Succeed REI if you don't know me. But go on there. It's a video I posted probably 4 or 5 videos back, maybe a month or 2 ago, but it's called How to Apply for Rental Assistance ERAP, and you'll see the thumbnail. I go through the entire thing step by step, and I talk about cooperation with the tenant, what I would do if I was trying to apply and work with the tenant. I've actually applied with tenants on the phone and with tenants there in person with me. I would go to that. I took a laptop with me, went to a tenant's house, sat down, hashed it out. Basically, I had to work for the relationship to make sure that it's not irreparably broken, but this tenant was able to, give me the information that I needed, and he was cooperating, and we submitted that application. I'm hoping that we'll actually be able to get funding. And that was the full 15 months because he owed that much. But definitely check out that video if you want to get some information on how to submit, how to answer questions, how that whole process works.
And you'll see down at the bottom, there's a ticker that we have. One of the landlord advocates, Vitaly, Succeed REI Real Estate Investment. Subscribe to our channels. We have so many videos on there. I think Vitaly's up to that 75 or 76, or we're up to that 68 or 69. So we have a lot of great videos on there, and our videos complement each other because what I may leave out, Vitaly will catch, and we're doing great. His videos are great. I watch his. So subscribe to our channels, watch our videos. Ladies, we don't make money. I yet have not been monetized. Vitaly maybe, and he might get enough every month to maybe buy a Happy Meal. So it's not, we don't make money on this. Our studio equipment, and I tried getting it to work when I had multiple cameras around, but it wasn't working for me tonight. And I like to focus my energy on reading this and studying it more than setting it up. But we have lights around us, we have cameras, we have sound equipment, computer systems. I've spent thousands, I'm sure Vitaly has.
Yep.
And the editing time that we spend on this, we do it because we care about you and we want to educate you. Now, 518 says, I thought courts were closed. Courts have been open for months. Some of the small town courts, they're not because they're afraid to open up. They don't know what to do. But we've had dozens and dozens and dozens of cases since February in court. They're open. It's a matter of where do we go and how far can we get in court? What will be the resolution in court? That's the problem. So yes, but you want to move your 18-year-old son in the apartment, a my-two apartment? Yes, you can do that. You have to go through the process of a holdover eviction by getting them out. But we're going to talk about that. I keep saying that, but we're talking and we're trying to pull up some questions. Let's see. Somebody that we may not have already talked to yet. Penalty under punishment? No, Facebook user. I wish we knew your name, but I'm going to call you a Facebook user. They're not going to apply that. They're not going to apply. The tenants are not worried about any of that stuff because there's provisions in there that all of us can fall under to claim that we're all suffering hardship. So they're going to do that. Like Vitaly said earlier, we could make claims sworn to and before on this day under penalties of perjury. We believe this. We have to hold ourselves, and the government holds us to a standard that they're not making the tenants do, which is not fair. It's not right. What course do landlords have to report on tenants that refuse to apply? There's nobody to tell they're not applying. You go forward with the eviction court date with ERAP or non-payment. You go forward, and then at that time they will say, I'm not applying, screw that program, I'm not doing it. Your Honor, you just heard him say, I'm not applying, therefore I want a judgment, immediate warrant of eviction. I doubt that the tenant will do that because under this law now, the court must inform the tenant of the declaration and the ERAP. They must, under law, tell that to them? Is it the tenant advocates are not doing that already enough? Now the court has to do it. And we have to do it too with paperwork that we have to provide all of the tenants with every document that was shown. So then they may apply just to shut you up and to keep the case going for another 4 or 5 months. And then from here, we're going to go on with the holdover aspect of this new law. I have a tenant who was just served a notice to terminate. We also included a hardship form. This tenant was originally living with someone else. And I challenged the form that they fill it out. Notice to terminate was, I assume, the 30, 60, 90 day that you want them to move out. They include, and yes, we include the hardship form, but it depends on what it is that you want to challenge. With a holdover, and this is a good segue to get into the holdover aspect. We believe, and my colleagues, see if you interpret it the right way too. This is a question that stumped me. Can we proceed with a normal holdover eviction for no cause or reason? In Albany, you can't. You have good cause. And they're trying to do that in New York State. I don't know if you did one by Tally, but on the landlord advocates, we had the good, the bad, and the ugly. Good cause eviction. We're not going to get into that now. Watch our channel. If Vitali has one left on his, watch his. But I don't know. And if Vitali, my team thinks that we can proceed with a normal holdover eviction of termination of lease or termination of tenancy in court without having to substantiate any lease violations or damages. Vitali, what do you think?
I did not think that we could. I guess let me correct that. If a tenant you're saying if a tenant does not submit a hardship declaration?
Well, they're submitting a hardship declaration, that we can challenge.
Yep.
The question was, can they challenge that? But we don't know what it is that you're challenging.
Right.
Is it because the tenant was originally there was someone else, and now there's only one person there? I don't know what it is. Please, that you're going to challenge. But that's the thing that's up in the air. Can we move forward with a holdover eviction if we're not claiming nuisance, safety hazard, or substantial and intentional damages? That's up in the air. Go ahead, Vital.
So I think, so there's two things, right? So there's, the way I look at it is two questions I would ask first before answering that question. Number one is, did the tenant apply for ERAP? If they did, obviously that halts any evictions regardless of what kind they are, even including holdover as I read it. Two is, once you serve them with the holdover for whatever reason, let's say the lease expired and you want them out with no reason, and they serve a hardship declaration, and the whole point of, and you can read in the prelude to the law, what the legislature is talking about is to prevent homelessness, prevent congregate housing situations, which is the same rationale that CDC was giving for its eviction moratoria. But the point of that they're trying to get across, the legislators, they don't want people to be evicted out on the street. So to me, as I read the spirit of the law, and maybe it's a little bit reading between the lines, but I personally think that if the tenant fails to submit a hardship declaration and they did not apply for ERAP, and even after they show up to court and there are advocates there giving them the paper, putting right in their face for a hardship declaration, they're still not submitting it, I think you can proceed with the holdover eviction. But chances are they will submit a hardship declaration, and then you're back into that realm of challenging the hardship declaration if you have a good faith basis to do so. But I don't know if there's just a straight path to holdover and to a judgment right now.
Yeah.
But
I'm leaning in that direction too, Vitali. It seems too easy.
Yeah.
And the people who wrote these laws, they don't want it easy for us at all. Even learned individuals like Vitali, myself, and my team, this is like, I was up 3 o'clock this morning just thinking of this crap. And it's hard on us. When you read some of this stuff, section 6 of part A, B, B, subsection, it's like, whoa, wait a minute. So I'm leaning in that direction too. And yet ask yourself this question too, landlords. If you're not evicting them for non-payment of rent, a destruction of property being noisy, why bother now? If it's something, and we've seen some landlords out there say, well, I just don't like my tenant. I don't care. You don't have to like your tenant. I don't care whether you like them or not. You're not having dinner with them. They're not marrying your daughter. Who cares whether you like them or not? So I'm leaning in a direction that you may want to try it. If you're willing to go to court and pay the fees or whatever, and you want to be the, what do they call it, the canary in the coal mine to see if it is dismissed, we'll be more than happy to help you with that. And any other firms such as I would be happy to help you with that, but we make no guarantees that the court will allow this case to go through. Because those are easy evictions. I just want them gone. We should be able to do that. Good cause eviction in Albany County, Albany City, and what may be proposed in New York State will no longer allow that to happen. And that's something that we need to fight. They're looking at that. But with that, I'm agreeing here with Vitali that I do not believe that you can. And even if you can, why take the risk? Because right now, we've seen some landlords too, Vitali, who are like, well, I want to raise the rent. But you want to raise the rent if somebody's been paying the rent right along during the pandemic? Don't be stupid.
Right.
Don't be stupid. Don't do that. And we did a video on that, Vitali, a few months ago. Late fees, late rent. We've seen landlords who have actually pushed tenants out by late fees and yelling, you're always late. Who cares? Right now, with the holdover evictions, I think what we have to really look at, and this law pushes it down the throats. They repeatedly intentional and significant damages to the property, not allowing for the quiet enjoyment of the other tenants or creating a safety hazard. Now, if you have already filed an eviction on a holdover, and now you want to go to court and claim all of these problems that they've caused, and you did not allege that in your 30-day notice, not 60 or 90, because when it comes to a nuisance or anything like that, you say 30-day notice. It still is. If you did not allege any of that in the 30-day or in your petition, your case is going to be dismissed, and you have to file all over again. Now, when you take the tenant to court for a holdover for damages and whatnot, you need substantial proof. In a civil court, a civil procedure is called beyond the preponderance of the evidence, and you better have a lot. The court will not go on your mere suggestion that they are causing a nuisance. If neighbors are there complaining, they will have to come to court and testify. You can't have a sworn statement from that because it cannot be cross-examined. So they're going to have to be there to testify. We had a landlord the other day who sent me photos of another tenant parking their motorcycle in another tenant's parking space. No, that's not going to cut it. It has to be drastic. It has to be excessive. And the thing that kills me is that there's no clear definition of what substantial damage is. One judge might say, you broke the bathroom door, you're out of here. Another one, you blew the roof off the house. Okay, now you're out of here. So what is substantial damage? So we have to be very careful. So when you come to us, and I would say Vitali as well, you come to any of us, we're going to look at what you have. And do not get mad at us if we tell you we do not believe you have enough to go on. If you want to push the issue, I'm sure that we will be more than happy to help you. Unfortunately, it's going to cost you money. But we're going to let you know up front, you may not have a case. So if your case is dismissed in court with prejudice or without, don't look at us and say, well, we told you so. We've done it longer than you have. Listen to what we're telling you. Now, if you have already filed for that, or not filed, if you have not filed for it, but you haven't contained in the 30-day notice, you will also take their transgressions that they have caused, and that will be inside of your petition papers. The court is requiring that you also provide an affidavit affirming or attesting to what you already had on the 30-day notice of nuisance of noncompliance and on your petition papers. It's already there. Now, some might say, oh, that's enough. No. Don't go on that premise that's enough. Some judges might say it is, but you must assume that every judge will say, no, it's not. So you would have a separate affidavit affirming what you already said on the 30-day and on the court papers themselves. Just add it to it. It doesn't hurt. It's another sheet of paper or 2 or 3. You add it to it. If you don't, you can find your case dismissed by virtue of not even having that affidavit. You can challenge that. On the holdover, that's the thing that we have to be careful of. The definition of substantial and intentional. Now, when we get into the discussion of defaults with the sheriff, that's when you landlords better take, maybe a value or something, because when we get into that, you're going to blow your step. It's really, really bad. So in the holdovers, it's very complicated. So we do have some notes here. Vitaly, I'll go over some of my notes, and while I'm doing that, if you want to add some things to the holdover end that I may have missed.
Okay. So what I was going to talk about, what I wanted to kind of touch base on, and I don't know if this is the right time to jump into it or not, because this actually piggybacks to the hardship declaration, and it would apply whether it's a holdover or a non-payment proceeding. But if you noticed, I think you've highlighted this page. I'm looking at page 52 in the 71-page law, and that talks about the expiration date, and that talks about which sections of the moratorium, the new moratorium that they have implemented, are expiring on January 15, 2022, and which ones are, or which one, I should say, is still in effect. And that is the rebuttable presumption reference. And this is why I'm saying, and I think Matt is saying too, if you have any reason, any basis to challenge a hardship declaration, you must do so in the timely manner. You must do so at the time that it's submitted, at the time you have the opportunity. Because if you don't, the way it's written is, if you don't challenge it, it creates what's called a rebuttable presumption, which just means that the judge will presume that there is a hardship unless you present some convincing evidence otherwise later on. So what a scenario that we're talking about, and this is how it ties into everything, is that you go to file against the tenant now in September of 2021. They submit a hardship declaration. You say, okay, well, maybe I can prove that they don't have a hardship, but maybe I don't want to bother with it. I don't want to spend on the attorney costs, whatever the case may be. On January 15th, the hardship declaration will expire and I'll be fine, right? Well, the problem with that is that they also amended the Tenant Safe Harbor Act. And the Tenant Safe Harbor Act describes what COVID-19 covered period is. And in one of my recent videos, I talked about how the previous description of what the termination date of that covered period that allows a judge to consider whether a tenant has a hardship defense against an eviction was previously very vague. So now they've identified that as more specifically as January 15th. So now we have a definite finite period during which a tenant could claim a hardship. Well, it just so happens that it lines up with January 15th. And if you were to wait until January 15th, and then you're seeking to evict them based on non-payment between September and January 15th, in my scenario, in this example, you will be faced with the prospect of still the Tenant Safe Harbor Act being in effect and the tenant being able to use the hardship presumption, because you didn't challenge it originally, against your eviction even after January 15th. This is how I'm interpreting this law. Matt, you tell me if I'm wrong on this, if your team has looked at it and they think that that's not how you read it. But that is my concern, because when you look at page 52 of this law, in section 11 talks about this act shall take effect immediately, and they list all these different sections except for the section that talks about the presumption, all expire on January 15, 2022, meaning that the presumption of hardship continues past over and above January 15th and will likely be used or potentially be used by a tenant as a defense to any future eviction attempts on behalf of the landlord. That to me is insane. That's the craziest part of this law, and they snuck it right in there.
I will be honest with you, they just didn't get in because I didn't get to that part yet. I was like, oh my God, because this law also talks about tax liens, commercial evictions, mortgage defenses. We did not want to get into that. But that's the point. I know when I look at this tomorrow, I'm going to read that through.
You're going to find new things. Yeah, absolutely.
And that's what we said earlier to you, landlords, is that we have a lot of answers, but not all the answers, because it's so in-depth. And I even said to some of my people when they come in, when they say, well, I want here, read this and tell me what you think. And they get the 1 or 2 lines and say, I don't know what that means. I said, well, what do you think it does to us when we have 71 pages of what you just read a paragraph and don't understand? One of the things that I'm glad I looked at my notes, and these are my notes, people that we have put together. I use 3 different color highlighters on these. if the court has awarded you, and I'm going to make sure that we get this right because this is so important, is that if in court, and I'm in 2 sets of glasses, one to read and one to see you, and right now in my reading glasses I'm not going to look at. If they already had an eviction already in court and they ruled in your favor, they are going to bring that case back to court.
Yeah.
All of them. And when the holdover ones, when they bring it back to court, it's terrible. And what makes me so angry and so disgusted with these people that pass this rotten piece of crap is that if you want to, you've evicted a tenant because they've destroyed your place, they're noisy, they're terrible, they're rotten, they're louder than a train going by your house, a tornado, Hurricane Ida has nothing on what your tenants have done to your house. So the court rules in your favor. They will bring that case back to court, and I will tell you what they're going to do. They're going to ask, the court shall hold it, if court has awarded a judgment against the respondent prior to the effective date of this section on the basis of objectionable or nuisance behavior, the court shall hold a hearing to determine whether or not the tenant is continuing to intentionally cause significant damage to the property or persist in unreasonable behavior that substantially infringes on the use and enjoyment of other tenants or occupants or causes a substantial safety hazard to others. Now, when you look at this, these cases are what we call adjudicated. That means the court has already ruled in our favor. They have already made a determination that there is, in fact, enough evidence to award you the judgment, and in this case, the warrant of eviction. You may get money for what they owe you after holding over. We'll talk about that some other day. But they granted you that, and now they're bringing the tenants back to court to see whether or not they are still being bad boys and girls. That's unbelievable. Your Honor, they broke up my place. They broke up the windows. And we've had people here on the sidebar who have said the damage that they have caused. And now I have to come back to court, even though I defended myself. I have to come back to court and say, Your Honor, or here's worse. The tenant says, Your Honor, I was just mad at my boyfriend. I was mad at my woman. I was mad at my girl. I broke up the windows. I had that happen when I first became a landlord. They got into a fight with each other. They knocked over the refrigerator and broke every single window in the apartment. They were ordered by the district attorney's office to make amends to me. The amount of money that I have, I don't know if you can see my hands. Do you see any money in my hands? I have yet to be paid. I'll never see that money. So why is it that talk about adding insult to injury, that now we have to sit with these people in the courtroom and have them say, now what happens? How do we prove that they haven't done any more damages? So is the court going to go, Vitali, on the premise that the tenant now has a little apron on, little Bo Peep, or the little bow tie for the boy and say, I've been a good boy. I've been a good girl, Your Honor. I haven't done anything bad anymore. I promise. Cross my heart, hope to die. I know I'm being theatrical when I say that, my friends, but for those of you who have followed me on and on social media, you know I'm that way. Because, Vitali, this is crazy that you have to substantiate your claim when you've already done it already. It's almost like a double jeopardy almost.
Yeah. I actually was thinking about that. Is there potential double jeopardy claim? I mean, I guess double jeopardy applies to criminal proceedings, but maybe there's a similar res judicata. I think that's the claim essentially, that maybe would be a challenge to that section of the law. But yeah, I think it's insane, and but the real reason is, once you know what the real reason behind the law here is, and I kind of always step back and look at the big picture with these things. I'm not as close to being on the ground, obviously, with the eviction proceedings and the details as you are. But looking at the big picture, as a landlord, as someone who owns over 70 rental properties myself with a business partner, and also being an attorney, and watching kind of the state and the state of our government bodies, the governor's office and both houses of our state legislature, the intent has always been there. It started when I started paying attention to these things was July 2019. It's when I first started posting on YouTube. But the thing that I started noticing is that's when they started tweaking the law to make it more favorable to tenants. And they've been slowly chipping away every single step. You got local laws that allow tenants to stay in their rental properties, barring there being good cause to evict them, that you can't raise rent more than 5% per year. All these rules and requirements and restrictions are coming here from New York City, where the whole purpose of it was that there's a shortage of housing, shortage of affordable housing, all these things, but it's been creeping up upstate and central New York and western New York. And the reason for that is because fundamentally there's a certain group of our legislators who do not believe that landlording is a legitimate way to grow wealth, make a profit, run a business, and to there's something evil and improper and wrong and unethical about being a landlord. Even the word landlord, they hate that word. I don't particularly care for the word. It doesn't matter what you call it, but it's a real estate investor. And I'm going on a little bit of a diatribe and kind of a side tangent, but this is what I truly believe. And if you guys follow me on YouTube and watch any of my videos, I've talked about coming to this country as a first generation immigrant. I was 12 years old when I came here. Family had nothing. My parents had nothing. Their degrees didn't transfer. We didn't have any money. Started from the bottom, had no advantages, no connections, nothing here whatsoever. And all it took, because of the great country that we live in, and this country is a great country, is hard work, taking the opportunities that we're given, learning about what opportunities exist, and then making something of those opportunities. And one of the best ways to do that, and I've been championing this entire time, is through real estate. And our state legislators do not believe in that concept. In fact, they prefer to rather for people to be dependent on the government, which is, as you know, someone coming from the former Soviet Union, you know I'm not a fan of that, okay, of any form of that type of governance. But that's what they want. The whole purpose of this is to use, and certainly the pandemic has been a hardship on a lot of people. It has hurt a lot of people, either from their health perspective and also from the government responses to, protect people from the pandemic and the virus. But they've also used this opportunity to restrict property rights and real estate ownership and landlord rights to as far as they could possibly restrict them. They know that there are certain limits. Supreme Court smacks them back when they go too far, but they've pushed it pretty far out from where it was just 2 or 3 years ago.
One of the things that, and I know Vitaly will catch on to this, I've told people that a lot of what's happening here in New York State happened in November of 2018. And some of November, what happened then, the election of 2018 changed the makeup of the New York State Senate.
Yep.
And a lot of what the Assembly wanted and the governor's office wanted was stopped at the doors of the New York State Senate. So the New York State Senate swapped control. A lot of what they wanted was like, oh my God, they were dancing in the streets. They were celebrating party that was $29.99. They were having a grand time. And since then, a lot of stuff, by the time I may even do, and we are going to do more videos, we're going to talk about some of those laws that they've had. We were going to do a video on the House of Stability and Tenant Protection Act, one video, and no, that's a mini-series. That's a mini-series. But there's other rules that they have had, and there's more that they're pointing out there that a lot of you are not aware of, that Vitaly and I are. The good cause eviction, they're looking at 3% rent increase. Anything more than that, they call it an excessive rent increase. Excessive? Now, you're going to laugh. All of you are going to laugh. I don't drink coffee. I'm a 53-year-old man that drinks chocolate milk in the morning. The price of my chocolate milk went up since I've been buying it, like 30 cents a half a gallon. It went up from, I think it was like $1. No, it went up from $2.79 to $3.19 a half a gallon. Okay? That's more than 3%. I can't go into the store and say, you went up more than 3%. No, you need to lower that down under the 3% threshold. But we landlords are subjected to so many regulations and rules, because like Vitaly said, is their form of oppressing us even more. And that's the word I have used so much since COVID-19 that I've ever used in my whole life. And that's what they're doing to us. And that's why when we look at these hearings that we have to have for a holdover eviction, And I want to go through more in case I miss anything. It was not pages 9, 10, and 11, Vitalio, the ones that I focused on from that mentioned the hearings that they had to have, the offenses that they may be able to use. Now, the other part that we had was defaults and warrants. Now, the defaults and warrants, that is where you have a tenant that did not come to court on the first appearance. The court requires you to have a default hearing. Those notices have to be served upon the tenants. The court did not provide those documents, so you have to go to a professional and have them done for you. And obviously we do that. They have to be served the declaration then, they have to be served that other cover page that we mentioned to you earlier, they have to be served this again on top of everything. So once they get that, you go to court on the default. Great. Your biggest thing, I will tell you, the greatest defense that you have right now is we don't want tenants coming to court. We don't want them to. In any case whatsoever, we don't want them coming to court. Because they will come to court. We have one Vitality. This tenant is a nightmare. She's a rotten woman. Just very nasty. She did not go to any of the court appearances. She did not go to the default hearing. She knows that the sheriff is on his way. And it isn't he on his way. And now she wants to apply for ERAP. She wants to apply for the declaration. And they're waiting until the very end to do that. So when we give them the notice of default, if the tenant does not appear in court at that time, the court should be granting you the relief that you're seeking in the petitions that you have filed or that professionals like we have filed on your behalf. If the tenant shows up at the default hearing at that time, then they may sign the declaration then, and you can challenge it. So that it can be made all the way through. Now, when the sheriff's department or the constable or the marshals in New York City come to throw your tenants out, that is the warrant of eviction. That is the thing that we all have been dreaming for and wishing for so much over the last 20 months. What will be 23 when this is hopefully all over. We'll get to that moment too. The warrant will be served upon your tenant. The tenant can actually give the sheriff the hardship declaration at that point. Now, the warrant paperwork, and I should have brought one here with me, has to have COVID-19 verbiage on it. If they don't, the sheriff will not execute. Our local court gave us a whole bunch of warrants the other day, and I said to my colleagues, send them back, we can't use them. They did not have the verbiage on them, which they should have. Now, from what we understand here, and it's applied in New York City, the chair of the City Marshal's Department in all of New York City, any warrant that has been issued prior to September 2nd, signed by the judge prior to September 2nd, is vacated. They make them come back to court and their status covers, even in a non-payment. So all of those that have not been executed, and when we say executed, means the sheriff is throwing them out and you change the locks on the door. That's executed. And that has not been done. And we know how long that process can take. Here in upstate, we're telling our people 21 to 28 days normally. Now it may take longer. In New York City, who knows? Either way, they're going to have now an opportunity to defend themselves once again. Now, it did say in one of these sections, Vitality, and I did not like this. It said here that in a post-warrant of eviction, that means after court, that at the status conference, in any eviction proceeding, if the respondent provides a hardship declaration to the petitioner, the court or an agent of the petitioner, blah, 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 the execution of the warrant shall be stayed until at least January 15, 2022. That's on page 48, Vitality, lines 1, 2, 3, and 4. I kept reading that over and I'm saying to myself, well, if that is true, what we read here, that could make this law unconstitutional. Because it's removing the due process ability that you have to say that your tenant is not suffering. Even though they took it to the 11th hour and 59 seconds before, bam, you're out, they still are allowed to do that. That section right there, and correct me, Vitality, and let's see it, we're on the same page, says that you cannot proceed and the eviction is on hold with the sheriff's office until after January 15th, which just happens to be a Saturday. Sunday, the 17th Martin Luther King Jr. Day. So they did that just the right way. That when they stay warrants until Friday, the tenant just bought themselves 2 more days. Legal aid and the courts know what they're doing when they do that. But either way, reading that, if that's what they hold up to, we may have an opportunity here to challenge that. What we are suggesting that we're doing, I don't care what it says right here. I mean, I do, but I don't. What I would suggest that you do, if that hardship is presented to you, and if it is presented to you after, you must write the docket number on the declaration, or the LT number, to the court and submit that to the court. The sheriff is mandated by law to provide that declaration of hardship if the tenant signs it. Now, we don't know, and this is another one, if the eviction was predicated on the nuisance and the damages, and the sheriff was already there to throw them out, will it be mandated to go back to court? Because as we said, if you've already had the hearing and the court issued the warrant, then it gets back to court. But if the warrant has already been issued to the sheriff, and the sheriff was on his way there or on her way there to throw the tenant out, are they going to make us have a status conference to see whether or not there's still being damage on the property, being a real choke? That's the question that we have. And if they are Vitality, we're telling our people we're going to challenge it no matter what. And then when the court says, no, we're not going to hear this case, then the lawsuits will happen. What do you think, Vitality? What do you think?
This is a tough one for me. I mean, obviously, kind of a procedural twister, right? With it's almost like a dog chasing its tail, right? That's kind of what I'm picturing with this. But I'm not so what's the argument, the unconstitutionality argument with this particular requirement? Can you flesh that out for me a little bit more?
Process. Because here, they're saying here that post-warrant of eviction, any eviction proceeding in which an eviction warrant has been issued prior to the effective date of this act, but has not yet been executed as of the effective date of this act, including evictions prior to March 7, 2020. Why they're still going on that is ridiculous. Right. But that's another argument. The court shall stay the execution of the warrant at least until the court has held a status conference with the parties. In any eviction proceeding, if the respondent provides a hardship declaration to the petitioner, the court, or an agent of the petitioner, or the court, prior to the execution of the warrant, the execution shall be stayed until at least January 15, 2022. If such hardship declaration is provided to the petitioner or agent, such petitioner or agent shall promptly file it with the court, advising the court in writing with the index number of that case. When I read that, when they have that section there, they might very well have something 89 lines later that may contradict what they said there, which is where they're trying to confuse everybody, including people that Vitali and I who know what we're doing. But when you read that, I'm looking at the due process because they're submitting that declaration again, and they're saying that it's on hold until January 15th. The warrant is on hold. Now you are presenting the same thing that the previous declaration did, that the self-attestation remains and you cannot challenge it. What say you?
So I think the thing for me that would make it problematic from a procedural standpoint and potentially a due process standpoint is if a tenant had already originally submitted a hardship declaration, perhaps they weren't successful with it, and the landlord proceeded to eviction, and now they're using this section of the law to submit another hardship declaration at the time right before they're served with the sheriff and getting kicked out of the apartment. That could definitely be a problem as I look at it, because then you didn't get, if you're the landlord, you didn't get your due process on the first time around because there's no effect to it. Like there's no enforcement of it. If the tenant can still do it and submit another declaration to stay the execution of a warrant again, even after losing on the original hardship hearing, then to me that would be a problematic interpretation. Now, I don't know if that is what they are trying to do, because maybe they're also just looking at, because there's another set of cases where there was no hardship declaration conversation done, right? Perhaps the warrant was obtained, issued prior to these laws that talk about hardship were passed, and that warrant is, landlords attempted to execute that warrant, and maybe that's what they're getting at. So they want the tenant to be able to have an opportunity to stay the execution of that warrant, and then the judge would have a status conference and they would figure out what to do then. Maybe that's the other scenario, and I don't know which scenario is going to be more common.
So you're thinking that they've already had the case, it's already been adjudicated, and the argument of the declaration has been defeated.
Yes.
Then once it gets to the sheriff, they cannot make that same argument over again.
I don't think they should be able to. That would be a real, end run around of the rule here, of the whole point of their response to the Supreme Court's August 12th decision. The whole point of it was to give a meaningful opportunity to challenge and review a tenant's declaration. And if you win that challenge as a landlord, you should not be thwarted again when you proceed to the natural conclusion of your proceeding, right? Which is the execution of the warrant. And if that's not the case, if the legislature is allowing this sort of double dip, then I do think that it's a constitutional problem for them. Absolutely.
But they did that earlier with the holdover, that they're bringing the tenant back to see whether or not they're still being a bad boy and girl. So they've already done it here. So now they're just kicking the can forward. It's a lot of people that said they're kicking the can forward, that they may be doing that again, only at the warrant stage. Hopefully that they're not. And a lot of us friends out there, you may ask, why don't you guys know this? Because it has not been presented in court yet. We don't know what the judges will say. This is all new. One of the 10 advocates at the landlord meeting yesterday, she was spot on with everything. We're actually good friends, and very good friends. And she has said these laws are changing ever so fast, and ever so, in many ways, they're very hard to understand and interpret, that we don't know how they will play out until we're in court to play the game. So far, everything has been very well with us, but it looks like warrants going forward. If we go to court now, and we've already had cases over the last couple of days, we had about 23 and 24, something like that in the last two. Those warrants that they go through, the sheriff's department should execute those warrants without the need for them submitting another declaration. My fear is, Vitaly, when they mentioned prior to September 2nd, and that is what the Marshal's Service in New York City has said. Anything prior to September 2nd, they have to have a status conference to see what's going on. And anything after that, I think we're safe. But that's the question that we have to ask ourselves, and we're going to delve into that. Not here, because we need that answer too, friends. We need to find out, are they going to have a status conference and have them have a holdover or submit the declaration of hardship, rather, after the sheriff was already come ready to throw them out? Are they going to make us do that? Now, this one, we have a holdover case from September of 19. Wow. Our last case, it was August 31st. Judge said he did not know what the new legislation allowed him to do. He should not be a judge if he doesn't know that. Lawyer said no new court date, but yet we were not yet granted the warrant to evict. Of course not. This has happened in some of the small town courts that we work with. And I tell you, you know what we're talking about with some of the small town courts. We had one that we went to the other day, and I won't name the court, but they have 3 different offices in that building. My garage is twice the size of where this is. We've had some courts where they actually have folding chairs and paneling on the wall. So those small town courts sometimes have a lot of trepidation on how to move forward. So what do? They don't move forward at all. And the law does not say that they cannot move forward. They just don't know how to, so they don't move forward at all. That is just as bad as this legislation that was passed. So in that case right here, the judge doesn't know. I would tell you, with all due respect to who that person may be, that person is not a judge. I would say they're probably a justice, a town justice, where you do not need to be an attorney. Whether that's right or wrong, some of them are great. I've worked with town justices who are spot on. And I worked with some that have called my office up after the passing of the House of Stability, who were on the bench and called a recess and called me up and asked me the interpretation of this law. And I'm like, wait a minute here. Why are you asked? And I'm okay to provide that. And we were honest too. I will tell you, we were honest. Whether the information was favorable to the tenant, we spoke the truth. We're not going to do that. And some landlords out there have asked, and I'm sure Vitaly has been in that position as well, have asked us to circumvent and look the other way. We're not going to do that because, one, we have reputations. We have a lifeline here. And we're not going to do that to hurt you. And we've told people away who have asked us to push the envelope and do this and that. And we will tell you, we have not been in business for over 30 years by doing that. We're here to help you. We're here to do the best that we can for you. And if you don't like the advice that we give to you, go someplace else and get the advice that you're looking for. We would never tell you one of the things, Vitaly, that we tell all of our people. I will never tell you what you want to hear because I don't care. I'm going to tell you what you need to hear because when you walk out of our offices, you're going to know the truth. And that truth should help you feel better knowing what goes forward. We're not going to fill your head with all kinds of jargon and all sorts of bull crap and make you think, hey, I won this one when you don't. We have seen, and I think we may, I don't know if I tell you, there's anything more you want to add on the warrant side of it?
No, I think we've pretty much covered it at this point. Like you said, I think it remains to be seen what judges will do with the law, what will come in the future months as this thing unravels. But I have a question for you before we move on to maybe if you're planning to wrap up, but I have a question for you.
We can go on as long as you want. I will tell you, I've gone over 3 hours. I'm not saying you have to stay with me.
Okay.
I've gone over 3 hours. So.
Here's a question that I think a lot of people might be wondering. What do you give as chances that January 15th is the true last end date for New York State eviction moratoriums?
I love that question. We have said on certain videos that we believe that it's not going to happen. It's not going to continue. And I will tell you, when I'm wrong, I run. And I was wrong to say I don't think it's going to continue because I just felt that the basis of it was removed. There's no mask mandates. There really isn't anymore. People are out in the public. The video I did with Kathy Holcomb, not with her, but about her, was about the hypocrisy of going to SPAC, going to legislative SPAC. Yeah. It's great to have Vitaly here too because he knows the area. I can mention SPAC, and some of you may, what the hell is that? Yeah. It's an amphitheater where a lot of people go. I've gone. I graduated from there. High school, that is, many years ago. But people are all out and about. I have said now, I think that they extended it by 5 months, so that it gives them 5 months to come up with some asinine, ridiculous, stupid reason to extend this once again. Will it be, it's cold outside and we don't want to make the children all cold and we don't want to put people out in the wintertime? Well, you're doing it to us. When landlords are coming to my office talking about killing themselves, crying tears, which makes me cry. I have literally cried over these laws, Vitaly. Not out in public, but I'm crying at my office, in my suite. I've cried at home over these. When I hear tenants tell me, or landlords rather, tell me their stories, and they're upset, and they're coming to my office, and I hug them and I hold them. I don't want to get to that point because I'm almost there now. It makes me upset. Vitaly mentioned earlier his background of growing up in Belarus and coming here and emigrating. I did not. But we have a video that I did way back ago of where I came from. I came from a background that is nowhere conducive to the life that I lead now. Drug alcohol family. I was homeless when I was 17. I had $40 in my name and a box of dirty clothes. That's how I started out this world. Welfare put me up in a cockroach-infested boarding home, so infested that when I threw the covers off of me, there were roaches in bed with me. It was summer of 1986. I was 17 years of age. Yes, I'm 53 years old. And I slept outside on a hammock, one of those, those outdoor hammocks. I didn't want to sleep in that house anymore. I worked my butt off. I have rental properties as well. I have a great business. I have a 3,500 square foot home with 18-foot ceilings. I have a beautiful home. I'm not bragging when I say that, people, because I go to the bathroom the same way you do. I put my pants on the same way you do. I have a great life because we worked our asses off, Vitaly and I have, to be where we are today. A phrase that I have used many times on social media is that people have to learn to overcome to become. And a lot of people out in this world, and this is another phrase that I use, and feel free, Vitaly, to use it yourself and anybody listening, is that for a lot of these tenants and advocates and other people in this world to complain all the time about us, because it's us, those people, they got money, whatever. It is much easier to complain and condemn the success of others than it is to create your own. And I'm not going to feel guilty about what I drive and what vehicles I have and the business, because one of the things, and this is not for you people watching, this is for the people that will complain to us and to you about what we have and what we do and all of that. This is now 8 o'clock at night, and I love being here. I look forward to this. I've done live shows before. I think this is Vitaly's first live show, and it will not be his last. I guarantee you that. I'll drag him onto the show. I look forward to this so much, especially being with Vitaly, because Vitaly's YouTube channel, Succeed REI, is much bigger than the Landlord Advocates. He's got almost 25,000 subscribers. I don't know how many hundreds of thousands of views that you've had on yours. We are small potatoes. And a lot of times in the YouTube world, collaborators only want to collaborate with those people who are equal to them. Educationally and all of that, Vitaly and I are damn close. But he has far exceeded me on YouTube. And when he said, Matt, I'd be happy to do that with you, I was moved. I was physically moved by him saying that, because it says something about who the man is that's co-hosting the show with me tonight. That he is saying, you know what, Matt, I want to work with you. And we have done private conversations on this, talking about how we're going to work together. And I have bragged to members of my team that Vitaly, I'm calling him a member of my team, social media, but he's so damn close to where I live that we are going to lunch and dinner very soon, and we're going to physically be able to meet. But we have overcome. And for the legislators to think that this is so easy for us, that we can get this money back and we can recover and do what we have to do to get to where we are, no. We've had landlords who have said to us, Matt, I can't pay my taxes. Matt, I can't fix up the property. What do I do? And I told them what the government tells you to do. Borrow the money. Where? I don't care where. Do what the government tells you. Borrow it. I don't care. Well, I do. But on behalf of the government, speaking for the government, yeah. I don't care where you borrow it. Just borrow it. Why don't they make the tenants borrow that money to pay us? Why do we have to borrow money to fix up our properties to the degree that we had it before they moved in?
Yeah.
And I can tell you, my tenants, Vitaly, in one of my houses that I was in court for, they did not communicate with me since September of 2020. August 31st, the evening of the 31st, it sends me a long diatribe about the condition of the house. There was one thing that I had paid thousands of dollars to get fixed, a leak I had paid, I approved, but he complained about the horrendous living conditions. I lived in that house. I put in $85,000 in a 1,400 square foot home, jacuzzi tub, tile inlays, $7,000 worth of appliances, washer, refrigerator, stove, dishwasher, and microwave, $7,000. I put a lot of money into that. And for him to tell me the horrendous condition, we're in court later on this month, and I can't wait to confront this kid and maybe his girlfriend there to tell me how horrendous it is. Because how foolish it is for them to go up against me, who has handled thousands and thousands of eviction cases over 30 years. To think that you're going to step up in court and compete with me? Now, I know that sounds cocky, but you know what, though? This is the landlord advocate who's here for you. Vitaly is here for you. So if what I'm saying maybe people seem as cocky or arrogant, that's for you, my friends. When you hire my team or you have us help you, holy SH, you are in for one hell of a fight. Because I don't call these properties yours, I call them mine. When these tenants are destroying the property, they're destroying my property. When they owe the rent money to you, they owe it to me. There are so many people out there who you can hire, and all they see with you is a dollar sign. We do not. If I did, I would not cry over these laws. I would not be doing what Vitaly and I are doing with you tonight. we would not be doing this. We would just not educate you and that you flounder, then hire us. And the time spent with you tonight and Vitali, we could be doing casework that we have sitting around that to help in-person clients. And we do it. But we are here because we care about you and we want to help you. Vitali, go ahead.
Yeah, and this, so I just have one point to make. I think this will be kind of my last kind of wrap up for me, and then I'll sign off. But I think you're absolutely right. I think that I want to be level and kind of balanced with everything. So I don't want this to be an us versus them mentality, landlords, tenants mentality. And, obviously legislators and government have that mentality, and they kind of feel that way, that the people who are landlording, who are investing in real estate potentially don't deserve it. They're using people, they're using tenants to become wealthy and all that stuff. So that's one perspective. The other perspective is, of course, a lot of landlords get jaded and they feel like tenants are pawns, and I don't want to personalize them at all because of these past bad experiences that we had. So I want to try to keep it balanced. I get it that with the pandemic and the government response, a lot of the middle to low income individuals who are also happening to be the group that rents more than owns homes were impacted in that they lost jobs. They couldn't continue making their payments for rent as well as other bills. And that I sympathize and understand. And, so I don't want to minimize that. There may be tenants that end up watching this video if you put it up on replay, but I'm not trying to minimize that. What I want is I just want some balance, and I want some understanding. And guys like us, like you said, we know what we're doing. We've got pretty good incomes. We've been doing this for a long time. We can withstand a lot of these waves and a lot of these storms that come at us imposed by our government. The problem is those folks who are in the comments who are talking about tenant owing them $70,000, or another person was saying they're owed $23,000. That could be an unbelievable amount of money that they can't overcome very easily, if at all. And there are a lot of bad apples, not all of them, and probably a tiny fraction of bad apples who are tenants who are taking advantage of the situation, just as I'm sure there are some bad apples who are landlords that are taking advantage of the situation. But the way these laws are stacked, it's a lot easier to take advantage of the situation if you're a tenant than if you're a landlord. And what these guys in legislature and the governor's office fail to realize is that these are not nameless, faceless corporations that own these properties. 50% of landlords in this country are mom and pop landlords at the very least. And so these are the people that have 1 or 2 or 3 properties maybe, and they worked all their lives, and maybe they're elderly or in retirement age. Maybe that was their retirement. And what they're doing is they're taking away those people's livelihoods and leaving them with no recourse for 23 months now going on, except for to spend thousands and thousands of dollars with potentially uncertain outcome on attorney's fees and help from guys like you, which is great, of course, that guys like you are out there doing this. But the problem is that some of these people, some of these landlords are unable to afford that. They cannot make ends meet. And it just feels like they keep getting hammered over and over the head by our legislature and by our governor's office. So that is what bothers me about the situation, and that is why I do what I do. And this is one aspect of what I do in terms of my social media presence and what I talk about, which is supporting those people who are looking to better themselves through personal finance, through real estate investing in particular. I want to be there for them. And this is one aspect that right now, over the last year and a half, has been pulling people back and holding people back. So I want people to overcome that and then focus on building that wealth and building that real estate portfolio and those other things that are not adversarial litigation context and laws. And how else are we going to get screwed today by our government? But the other side of it, which is the happier side, the fun side, which is investing in real estate, growing your wealth, getting to a point where you don't have to rely on a job and so forth. So that's where I want to get back to. But the problem is that we've been stuck in this rut for a year and a half plus now, that it's very hard to do that at the same time as you're battling these battles. So So that's pretty much what I would say on that.
I want to respond to what you said. And
Sure.
you know, he hit it on the head in that I'm angry with this stuff, but really it's the legislature and the governor's office and other entities across the United States that have allowed the bad tenants to do what they're doing. And therefore, they're giving all the tenants a bad name. You're going to see landlords who are warehousing apartments. And for those of you that don't know what that means, landlords are holding on to apartments and they're not renting them out because it's so hard to get rid of them, the bad tenants. And I will tell you, in the years I've done this, we work with so many tenants. We actually, Vitaly, have had landlords who would go pro se. And they will see me in court and they will say, I want to work with that man. And they don't know that my office is the one that's facilitating the eviction of them. We've also had cases where tenants have cried. They had their case, and my colleague may be up at the table. I might be sitting down in the front row where we sit in the court, and they will come out and they will give me a hug. I've had tenants that our office have evicted who have later went on to become landlords themselves and have hired our office to help them. I will tell you, with Vitaly's background and mine, we know what it's like to do without. My clothes came from Sari Shinami, the Sally House, and even through college, I was getting my clothes there. And I would grab the suits, and I would pray to God that they would fit, because I didn't have the money to get them hemmed up. That's how I hope they fit. And that's where my life was. So I can appreciate both sides of the fence. But when I have my dear friend Donna, who works with a local organization that helps tenants and works with landlords. She was at the meeting yesterday. She's been at my home for Christmas parties. I gave Donna a hug yesterday. I haven't seen her in a while due to COVID. I work with other programs here in our area. I won't say what they are because that's for them. Vitaly would probably know them if I mentioned to him off air. But we work with these organizations. They would call us up and they would ask us for help. They complimented our team yesterday and how we approached and worked with them in court. And they will call us up, hey, Matt, what do you think? If we were such bastards in this process with tenants and tenant advocacy groups, they would not talk to us. Legal Aid has worked with us many times in court. They have even come to our defense when the court realizes that, something's missing in the file, and no, it's not. We will work with legal aid. We are friends with legal aid. Not all of them. I will tell you, not all the legal aid attorneys are. Because some of them are brand new and they're trying to make a name for themselves. And they will do it at the detriment of working with. Because sometimes we're going to win, and sometimes legal aid is going to win. And some of the newbies, the new attorneys, need to realize there needs to be some level of cooperation between the two. We may not all going to walk away with a giant smile on our face, but as long as we walk away with a okay, I lost, I won. He lost, I won. So you're right. We don't want it to be an adversarial relationship with tenants. We absolutely do not. But some of them make it that way. They are enjoying the fact that they can't be evicted. They're enjoying the fact that they're not paying the rent. They're having a grand time. For those tenants, and there will be tenants that will watch us. For those tenants that are doing that, I don't care what happens to you. I don't care if you're living on the lake, living on the side of I do not care. And put it on the record. But if you're somebody that's trying, and the courts know all in the area of Vitaly, all of them, from Albany to Waterville and every letter in between, know that if you are trying, Ideal Legal Support Services and my team will roll the red carpet out to help you. We've done it many times, and we'll continue to do it. Now, I will tell you, there was a comment up here that I want to share. Harleen Andrus. I'm going to call her out. She's probably getting all red-faced right now. Harleen, when I mentioned my team is Mark Judah. My team is Joe Volato. They represent all of our landlords in court with us. There was myself. There is Kim Scannell. She's a real estate agent, and she focuses on a lot on title search. And there's Harleen Andrus. Harleen Andrus owns Homes by Harleen, and her specialty is leasing and tenant placement. She is a wonderful dear friend of mine. I love her to death. She took me out for my birthday. A bunch of us went out to a nice dinner and had a great dinner. Texas de Brazil at Crossgates Mall. We went, Vitaly. We had a great dinner. wonderful time with her. She is a dear friend, and she has helped me. There was a time in my business where there was some really bad stuff going on. I won't go into it here. There's litigation pending on that, but she jumped right on board with me from day one. She's been a friend of mine, and Harleen, you know I love you. I know that she was at the meeting yesterday. I love Harleen, and I have to call her out on that. And she'll probably send me a text message momentarily saying, "Oh, Matt, you embarrassed me." Well, I don't care because I love you, woman. She's a great lady. But Vitaly, you're free to go. Your bail has been, given back. You can leave. You can stay. I will tell you, if you are landlords, I want you to know Vitaly CREI. Subscribe to his channel on YouTube. Hit the like button on his videos. The notification bell. I am very flattered that you wanted to do a collaboration with me, and I hope this is not the last one that we do. We're going to do more. This is his first live show, everyone, but I'm going to tell you it's not. Because if he thinks it is, I'm going to contact him and tell him that he's going to do more. He's very educated. He's very, very poignant with what he says. He's right on par, because if he wasn't, he wouldn't be here with me. And we've had people, Vitaly, out in the real world, in our world, not the social media world, who have asked me about my team. Well, Matt, what do you think? And I have said they would not be on my team or our team if I did not feel that they would do a good job. I have a damn good reputation over 30 years in this community. I have over 1,300 clients. And if I felt Vitaly was not of a high caliber, of knowing what he knows and caring the way he does, he would not be on this show with me tonight as my co-host or even a guest. He would just be somebody that I would wave off like a fly. That is not Vitaly. I am flattered that you were here with me, Vitaly. I appreciate it. I'm very thankful, and you have to come back. Or if you do a video and you want me to come on as your guest, and you can control what videos come up or what comments, I'd be more than happy. Just let me know.
Sounds good, Matt. Thanks so much for having me on. Thanks, everybody, for joining in and listening and leaving your comments. I appreciate it, and hope to talk to you soon.
Absolutely. Thank you, Vitaly.
Take care.